selection process matter.
Selection process. Which year?
This year. Fresh matter. Fresh matter. That I have filed. Fresh matter.
Fresh matters. Fresh matter means fresh matter of pronunciation. Yeah.
This is 22 matter, my lord.
2 weeks.
The area salary of the petitioner is from 22, it is
Not been
from
paid.
2000, it has not been paid. From 99 till 2008.
Week after next. Week after.
Challenging the process of selection of CRCC. My case has been rejected. Though violating guidelines, they have selected other persons, my lord. 25.
25 matter.
My lord.
After notice or pre?
After notice has been issued to obtain instruction.
Yeah.
They go on processing.
2 weeks. 2 weeks. Okay.
Pension matter. Pension matter after notice matter.
Which year?
One is 24 matter.
24 matter. All right. 3 weeks.
Another is pension matter and this year.
This year.
Not after.
Same.
Proceedings complete with regard to the area salary that has not been paid, even though bill has been submitted to the government, but government has not been paid, madam.
Which year?
2025, madam.
25.
Yes.
All right. We'll have it last week of September. 3rd week of September. All right. Where is the other? Only one lady. Anybody wants adjournment?
Yes, sir.
Which matter?
Serial number 9 to 12, my lord, next week.
9 to 12.
Yes.
Which year?
This year, madam.
This year only.
Yes.
After 2. Check the request. You inform the other side.
Yes, sir.
My lord,
Yes.
item number 3, the case is adjourned to health condition.
Item 51. Subject to my lord's action. This is a matter, my lord, I mentioned last week. My amendment has been rejected by the tribunal and posted for hearing. My lord allowed my memo. I pray, my lord, item 51, last item. Maybe taken up before my lord trial.
People raising of the court today. Urgency.
My lord, they rejected my application for amendment and posted for hearing of the matter, my lord. I remember I mentioned last week, my lord.
Before the tribunal.
Before the tribunal, my lord.
Oh, educational.
As you are, my lord.
51.
Last
year. Suppose if it does not reach just pension, I'll take up.
My lord.
I mean, pardon, my item number 46, my lord.
46.
It is a matter. I am the respondent number 6, my lord. That the last occasion case was listed. I submitted to file the objection, my lord. But my client is sick, so I am not filing objection. I will inform my
friend you have informed.
I will inform my appellate advocate.
2 weeks at the request.
Any date, my lord.
2 weeks it will come.
46 is not yours.
46.
46.
You should not get adjournment of other cases.
Respondent number 6.
You are for respondent 6.
I will inform my lord.
That's the request.
I have to file the objection, my lord.
All right.
My lord, item number 3, due to health condition of the serious, it may be adjourned, my lord.
Serial number?
Item number 3.
3. Which year? 25. Right after 4 weeks at the request of joint counsel on health ground. Yes. Pronouncement of the
Item number 1.
He's saying.
I think materiality no appointment of 103 crore. In the matter of 2040. Till date they have not yet.
You came running to the court.
My lord.
You came running to the court.
My lord.
Which year?
14.
2014.
My lord.
Take next.
Whole memo, sir.
My pardon, lord. This is metro. This metro was listed on 88 2025. It could not reach.
Which year?
2024.
24 matters. Taking up the 2 matters.
Next year.
There are 2014 matters.
No, it was on list 18th August.
Yes, brother.
I find an angry for intervention fellows in the matter of that teachers' fellows, LTR teachers' fellows. In the 2025 recruitment, the whole process has been stagnated. Yes, fellows.
Entire process itself is stagnated or only one?
Entire process, fellows. Due to the stay order, my lords. I filed an IE, my lords.
Next week we can have this matter.
Yes, my lords. I filed an IE, my lords. An intervention.
What's that? Yes. Broadly, we have accepted your version, and I have set aside the order, holding that your client was not holding two sides. And I have also discussed what is meant by possession, which Samant has discussed. I have quoted one judgment of the Apex Court, what is meant by possession. Okay. And the fraud, etc. P. Changalavarai and I have just quoted. I have treated that aspect also.
One prayer.
Therefore,
May it be marked as A for, I have searched, our High Court doesn't have such an order as in today. If this judgment is marked A for, it can be.
are there many other such matters?
There might be other matters, my lord, but till date, I have searched some of the books as I have. I couldn't find a judgment in this regard. As your lordship, the other time.
I'll just go through this judgment again.
Yes.
If I feel its quality is worth reporting, then I'll take it. All right? But you argued very well, although both of you took more time than usual. That happens sometimes. In the above circumstances, this petition succeeds. A writ of certiorari issue, deemed order, and as a consequence, there shall be no action from the side of opposite parties that would affect the ownership and possession of subject house property of the petition. What claims? I wanted to refer to Kerr on fraud. There is a famous book, Kerr, K-E-R-R, Kerr on fraud. Very famous book. In our library, I could not secure that. Otherwise, how fraud should be treated. Fraud in public law, fraud in private law.
Yes.
Fraud in admixture of public and private law. That's another aspect. That since I could not locate that book, I have written, but I have mentioned other things. I'll try to push that book also if I get one.
Grateful.
Item 2. Yeah.
May I please, Lordship?
Yeah.
Prior to go to main case, Lordship, I have filed a IA for amendment, Lordship.
IA for
Lordship. IA number 7010 of 2025, Lordship.
what for
It's for amendment, Lordship, as because advertently I have omitted opposite party number 4, though in contents of writ petition, Lordship, in pair part as well as in body part, Lordship, I have mentioned as opposite party number 4, that is, Lordship, land acquisition officer, Cutter, Lordship. But advertently I have omitted the as opposite party number 4, Lordship.
You want
in
it-
cost title part, Lordship.
It is it for implement or implement?
Include, Lordship.
Only
The same as opposite party number 4, Lordship, in cost title part, Lordship.
only title part.
Title part, Lordship.
No other
No,
changes.
there is everything is correct. Lordship.
Admission has not yet happened.
No.
Not yet happened. Petitioner has moved application number so and so, supported by an affidavit seeking leave of the court to add a particular official as additional fee in the OP to the petition. First, petition is at the stage of pre-admission, and therefore, ordinarily, such requests cannot be negative. First one. Even otherwise, the party whom the petitioner intends to arraign as additional rest of OP appears to be a proper party if not a necessary party, in the light of Apex Court decision in Rajia Begum versus Shahnaz Begum, AR 1958 SC sites. First, next paragraph. In the above circumstances, application having been favored, leave as sought for is accorded for amending the cost title by loading the particular official in the array of parties. Yeah, have you amended?
Already filed cost title, amended cost title, Lordship. Already filed.
The amended cost title filed in advance in disorder is accepted. Yeah, have you signed? You have to sign an amendment. You have to make a mark by red ink that you have added wide court order dated so and so. This party is added as the copy number so and so. That you have to do. Therefore, I am prescribing T2 Indian practice by Mullah. Mullah gives all procedures, what should be done. Otherwise, in CPC, you will not find. Okay? Just amend that. Call this matter next week. Last. Item 4. You have taken, I have given my list also to you. I'm not that accustomed with this kind of listing system. Just see. No, so I have it. So let's see it. Yes. Next. 3.
Matter of regular for government. This is a matter of regular for government, madam.
How long he has been?
She has been in 2008. Has been appointed as government. Gadget notification, he should have regularized since 2016. Instead of that, he has been regularized in March 2020.
So, antedating of regularization.
Madam.
Okay. We have admitted similar matters with the issue notice. Issue notice. Learned AGA is requested to accept notice for the office. Call in the last week of October. October, you have vacations. Last week of October is vacation. In the second week of October. Yes. Item 5. 5.
Here the petitioner daughter applied for admission in the Odisha Adarsha Vidyalaya in the government employee category. And she was provisionally selected. Selection list, kindly have a glance. Page 16. Her name found place at serial 64. That Sonali Pradhan. And thereafter,
Mr. Bradley, 1 minute. The last, on 5th of August, your lordship directed us to obtain instruction in this matter, to which I have got. In the instruction, it is stated that during document verification by the principal concerned, the required documents with regard to employee of the state government or state PSU category was sought for. Upon verification, it was found that the petitioner does not any formal appointment order, does not have any service book, and no HRMS generated salary slip. The factual report furnished by the principal, Orissa Adarsha Vidyalaya, so and so Puri, is enclosed. So he has not submitted that. That's why.
No, where are you? Where you are
working?
yes, page 30.
30.
Yes, 30.
Go to 30.
This is the service certificate. This is certified that
There is a contractual.
Where does it say contractual employees more in favor of Orissa? I have been seeing thousands of cases of contractual employees.
Probably have a look to the their
page 22 guidelines.
Guideline.
Guidelines 1.4.7.
In the guideline itself,
They are checking PSU, but contractual employee they will not take.
He is saying something. You have to permit him.
Page 22.
entire guideline is with me, my lord.
I have annexed. Page 22.
Your lordship.
Permit him to speak.
We are to act in accordance with the general guideline for admission of students in other services. Year 25-26. In that guideline, the contractual employees are not words. I'm just reading. No. The words of serving state government, state PSU employees can apply for Orissa Adarsha Vidyalaya of their native block or for one of the Orissa Adarsha.
Your temptation.
Yes.
The guidelines I am providing for your lordship.
That's right.
Reading that, I can remember easily. I can reproduce everything if you want. Yes.
Because of the fact that he is not coming under this category, his case was not considered.
Where does it exclude contractual employment?
But it is not excluded. It is also not included.
Included is not necessary. Excluded is necessary.
It is there. It is not there in the guideline.
No. We don't agree. They are working for the state. How many years you have been in the employment?
Since 10 years, more than 10 years.
10 years. 10 years prime period.
Accountant comes supporting staff in block education office.
They have given the certificate.
Yes.
Kindly see that annexure. What is that annexure, brother?
Annex 3.
Annexure 3, page 30.
It's not a government employee, man.
He who comes so and so, he himself has said he is working with us.
Accountant comes support staff. He's not a government employee, man.
No, where is the requirement of civil servant? Word civil servant is not there.
State government, serving state government.
He is serving state. Whether he is serving state is the question. The school is the government school.
He's not even a PSU also he's not there.
No, PSU leave it. But whether government school, is it a government school or not?
Yes.
Then it is working in the government school.
No, they are not working. They are not government servants, I said. He's not a civil servant.
Where is the word civil servant?
Civil servant, it is serving under the state government. The persons, the employees, those who are serving under the state government are civil servants.
Not correct.
He is not.
Broadly. No, the word civil servant is not used. Civil servant is described by the apex court at least about 3-4 decisions.
Yes, I know.
Question me, is he in the service of a government school or not?
No.
He is.
My lord, this is certificate that Puri is serving as accountant come support staff at BO Ranpur under the district since 2016 till date. This was Samagra Shiksha Abhijan. Yes. Samagra Shiksha Abhijan is another project. It's a society. He is working under that.
Under society.
Society.
Samagra Shiksha Abhiyan is a society.
Registered
society of government.
Government. Yes.
Government society.
Government society.
Then it partakes the character of PSU.
No, it's not PSU even.
Why?
No.
How?
It's not PSU. It's society. It's a registered
government society. Because society registered by the government is Article 12 entity.
Yes, you should explain that and pass on.
Please be seated. The short grievance of the petitioner is as to denial of admission to his daughter in which school? OP number?
OP number 4.
OP number 4 school on the ground that petitioner is not a civil servant and therefore the extant guidelines do not provide for any relief. First off. Next paragraph. Kindly be seated. Learned counsel appearing for the petitioner, drawing attention of the court to the document at Annexure 3, dated, what is this date, brother?
1/4/2025.
1/4/2025, issued by DO cum DPP of Samagra Shiksha Nayagar tells that that his client is in the service of the Article 12 state entity under Constitution, and if the partakes the character of a public sector undertaking. First off, so arguing, he seeks to alter the decision impute, coupled with a direction to admit his child to sixth standard in the subject school. First off. Next paragraph. Learned AGA, on request appearing for the OPs, vehemently opposes the petition, contending that under the policy guidelines, it is only the civil servants whose children are entitled to gain admission to the of the kind, and that petitioner not answering that description, cannot seek admission for his daughter. First, he reads out the particular clause in the guidelines in support of his contention. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter in as much as the expression civil servant is conspicuously absent in the guidelines. First one, added, learned AGA in all fairness agrees that the children of employees in the PSU are entitled to admission. First one, the word PSU, the word public sector undertaking, serves the description of state in the light of apex court decision.
It's a society, I said.
I'll come to that also. In the light of apex court decision in Sukhdev Singh versus Bhagat Ram, wherein Oil and Natural Gas Commission was held to be an entity under Article 12 by the Apex Court. First off, that apart, the very concept of instrumentality of state under Article 12 itself has been expanded in a series of decisions, including the International Airport Authority Limited, Raman Dayaram Shetty.
Ramanna versus Airport Authority.
Raman Dayaram Shetty versus International Airport Authority Limited. It is Supreme Court. Just look it. Science. First. Next paragraph. Learned AGA vehemently submits that the school in question is run by a society which is registered by the government.
No. That
is it aided?
no.
It's a government school.
School is a government school, but The employee is working under a society. That is what my submission is. Your
Working
Lordship.
under a society.
Society, registered society. Lordship, Annexure 3, your Lordship may kindly have.
There is a funding of central government and state government,
Ah.
60-40%.
It is
Of that to that society.
that society.
And
Registered society.
the details is given in this judgment. Details given.
Why can't you sit down
My lord.
instead of spoiling your case? You want to spoil your case? Or you don't want?
Yes.
You don't want? Be seated. Kindly be seated. I'm doing something.
They are misinterpreting.
No, I am not.
Misinterpreting.
I am not.
There is dishonorable code.
I am not missing.
They are with the government employee and their payment salary has been sanctioned par with the government employee. This is the judgment of dishonorable code. Details written, how the project runs, what are the factors, everything has been mentioned and they are misinterpreting.
Misinterpretation you can use.
Accountants from support staff, same.
Misinterpretation.
Lordship,
You,
I am not.
I only say this much.
My lord, please.
That you should not use misleading, etc. Against the government and all.
No, I am misleading not. I am saying misinterpreting,
That is right.
not misleading.
Kindly sit down. Sit down till I request you. Do not stand up also. Okay? Learned AGA appearing for the OPs further submits that though the school in question is a government school, petitioner is only an employee of a society registered by the government
Registered under Registration of Society Act.
under the provisions of Orissa Society
Registration of Society Act, yes.
Registration of Society Act. How the Orissa Societies Registration Act, is it like that? Orissa Registration of Societies Act?
Yes.
19?
Societies Registration, Central Act it
It
is.
is Societies
Registration Act.
Societies Registration Act.
Society, yes. So that here is not known.
No, it's very old act, Society Registration. Society Act. And therefore, the petitioner does not fall within the custom. Per contra, learned counsel appearing for the petitioner draws the attention of this court to a coordinate bench decision in Purna Chandra Bag versus state of Odisha and others, wherein the nature of service of employees of petitioner's kind been discussed, and at para 3.10 discussed.
Funding ଆସିଲା answer ଆସିଲା answer ପହଞ୍ଚିଗଲା ତାକୁ ଏଟାକୁ convert କର ମନ୍ତ୍ର ଶିକ୍ଷା ଅଧିକାର includes secondary
Wherein paragraphs 8 and 8.2 read as an first off. These observations should be a complete answer to the issue raised by the to the objection raised by the learned AGA. First, in the above circumstances, everything is covered against you. In the above circumstances, this petition succeeds Semicolon. Any order is issued quashing, etc. You are not entering
Only to direct for admission.
a writ of mandamus issues to the respondent school to admit OP4 to admit petitioners Miss Sonali Rajalakshmi to sixth standard. Sixth standard.
In Odisha Adarsh Vidyalaya, Jamlagoda, Konasopuri, that page 13. School name is mentioned.
In that OP number, that OP number 4 only, no? Course made easy. Okay. Everything is answered. He is right. Therefore, he was raising his voice. Everything is answered.
Year 79.
79 is
Supreme Court 1628.
1628. Can you find out Sukadev Singh versus Bhagat Ram? Anybody?
Yes. Again.
Yes.
I think. And Societies Registration Act is of the year 1860.
1860. Therefore, I felt it's a very old act. The Central Act. 1860. First Law Commission's recommendation.
Sukadev 75 Supreme Court, man.
75 Supreme Court right now. 1975, 75 years. 331.
3-1.
Yeah. This is just the pattern of the order. Little linguistic modification will undergo. Yeah.
Item 6.
May I submit on behalf of Mr. Naik?
Yes.
Now, here, my lord, petitioner was appointed as a peon.
You are standing in between two mics.
Sorry,
That is not.
But petitioner was appointed as a peon, fourth peon, my lord. His appointment, though, was approved, but subsequently was cancelled on the ground that fourth peon post is not admissible. This matter was decided by this Hon'Ble Court with a judgment that the person who is in fourth position is to be promoted and next person is to be adjusted in the post of third peon, and one Daftari post which is admissible after the roll strength exceed 100.
There was one judgment which I wrote like this.
My lord, have already issued
recently, where Mr. Identical question I have covered. Division bench judgment.
I will verify on Monday.
Take notice. Issue emergent notice. Learned AG requested to accept notice for respondents. All respondents.
All respondents.
But I think the court has a panel counsel.
No, man.
They have. We have notified panel advocates, not government advocates now.
No,
issue emergent.
This is of a school. School peon.
Okay. Therefore, AGA will accept this. AGA requested to accept notice for respondents. Yes.
Lordship directed to get the matter listed in the second week of September or
third week of September.
third week of
I have given the serial
along with WP number.
I have given the order, man.
Okay. Yes.
Item 7. May I please, Lordship? May I?
Yes, sir.
The petitioner has objected the illegal construction of a community center upon a government land, that is the forest or Gramya Jungle of Kisam.
That land is used for?
Gramya Jungle Kisam, that is
village forest.
Village forest.
Village forest. Kisham is
Village forest.
village forest. And my lord, should I interrupt?
Yes.
My lord, if you will give a representation to the collector, probably
It's
his
Annexure 4, Your Lordship.
You
Probably-
consider that.
yes,
Annexure 4 or on page 20.
problem can be solved there.
The short grievance of the petitioner is as to non-consideration of his representation dated
12/7/2025.
This is
12/7/2025, a copy whereof avails at annexure
my lord,
4.
this representation he has given to the BDO.
I will tell him to send it to another
Yes,
Collector, Your Lordship.
collector.
collector.
No, he has given collector. Collector. In English, he has written that.
Yes, my lord.
Yes. Wherein he is raising an objection for construction being undertaken on a government land unauthorized. First, next paragraph. Learned counsel for the petitioner submits that when a representation of the kind is given, the OP number, OP number 2 could not have kept it in cold storage, and therefore this court should come to aid of his client, consistent with the mandate enacted in Article 350 as broadly interpreted by the courts, of the Constitution of India. 350 of the Constitution of India as broadly interpreted by several high courts. First. Next one. Learned AGA, having resisted the petition for some time, now graciously the suggestion of this court that the subject representation has to meet its consideration at the hands of OP number 2 in a time-bound way if all the contentions are kept open. First, this is appreciated. Next paragraph. In the above circumstances, petition is disposed of. Time for consideration and informing result of consideration to the petitioner is 6 weeks. Yes. First of all, contentions are kept open. Next paragraph. It is open to solicit information document from the side of petitioner as are required for exercise. No cost. Copy, web copy. Even earlier also web copies. Okay.
Minor till disposal of my representation.
Nothing can be done.
Yes. IA
fails into insignificance since the main matter itself is.
Item 8.
Yes.
Please, your lordship. My lord, I am petitioner, assistant teacher, already retirement, my lord.
Retired. When retired?
2018, my lord.
2018?
Yes, my lord. The petitioner challenging quash the order Annexure 8 and Annexure 6 illegal and arbitrary order dated 18/1/2025 passed by District Secondary Education and page Annexure 8 page 39 and Annexure 6 page 27, my lord.
39. What is that order?
Annexure 6, my lord. Paragraph. Therefore,
6 is original order. 8 is appeal order.
Yes, my lord.
In 6, what was said?
Annexure 6, page 27. Therefore, in considering the written statement of defense of the delinquent and basing on the inquiry report of the inquiry officer and after careful consideration, the departmental proceeding drawn against Sri N. Chandrasekhar, petition, my lord, is hereby closed, awarding minor penalty censored his period of suspension from 13/11/2017 to 21/7/2018. It is treated as such.
As such.
Yes, my lord.
Treated as
such. As such means that period.
She will not be entitled to
benefits.
Monetary
service benefits.
Service benefits. Monetary benefits or service benefits?
My lord, there is a break in service. It is because it is
like followed in service only.
My lord, it is because it is followed by a punishment.
Censure.
Censure
is enlisted as a punishment under your rule?
Yes.
Well, but well, Annexure
minor penalty.
Minor penalty.
Yes. But my lord, Annexure 8 authority page number 42. 5 point, my lord. The disciplinary authority should have imposed a major penalty for such gross why he is so generous towards the appellant by impose such minor penalty based on to him, my lord. Decision, my lord, the appeal petition has been considered as above. The claim of appellant has no merit, as such it is hereby rejected. That disciplinary authority is DO Ganjam is hereby instructed to drop the award. Censure of the penalty is not covered under Rule 15 of the Rule 1962. Rather, the appellant must be awarded penalty as prescribed in clause 6 to 9.
He says censure is not a penalty at all.
No. It is a minor penalty, my lord.
But it's not a penalty at all. For some other penalty can be.
Major penalty he is referring to. My lord, here, lordship may kindly have a look to the proceeding.
What was the conduct?
Allegation.
What was that allegation?
My lord, it's a black scar in the teacher's life, your lordship.
What is
Guru? Page 17, your lordship may kindly have a look.
17.
Page 17, Annexure 3. Statement of imputation of misconduct in support of article of charges. Charge number 1, the lordship may kindly have a.
Then what
With this conduct, my lord,
it cannot be a minor penalty.
Yes.
Kindly see that.
My lord, I'm
Kindly see that.
putting a question to myself, my lord. With this conduct, will the teacher be there in the school?
Therefore, he has directed reconsideration.
Yes, major penalty.
It's not a case of minor penalty. It's a very famous
Serious,
misconduct.
My lord, after retirement, against a proceeding mine, 50%.
No, when he did it, was it
Initial 4 million.
Before retirement.
before retirement?
Before
But when
retirement.
did you initiate the proceeding?
My lord, before retirement? It will
Initiated
continue. Rule 7.
before retirement.
Yes.
50% salary release, my lord.
When did you retire, sister? 11/7/2018 is the initiation.
Retirement by 2018, my lord.
2018
18.
date.
2018 हो जाता है.
11/7 is
No.
31st 12/2018.
Huh?
31st 12/2018.
But therefore it is initiated when you were in service. There is nothing. What the appellate authority has said. See what the action. In fact, learned AG was hesitant to read all that. I have read it now.
50% salary, rest of it 50% salary not release and
suspension allowance, madam.
If you suspend, that is subsistence allowance. Even subsistence allowance is not given.
Yes, he must have got.
But that you have to verify.
Yes, I have to
It's
verify.
treated as such.
Yes.
Then entitled to subsistence allowance.
Yes,
Notice only for that limited.
yes, I'll get that instruction.
Learned heard Miss
S. Mahakuda. S. Mahakuda.
So who argued very efficiently and made out a case for admission. First off, issue notice. First off, learned AG on request accepts notice for respondents. Call this matter after 2 weeks, since it involves it lies in a narrow compass. You are very impressive argument. Yes.
Item 13.
Yes.
Review the petition challenge the order of rejection unnecessary 11. Unnecessary 11 rejection for
Only thing is you have to ascertain whether that learned AG to ascertain whether subsistence allowance during suspension period has been awarded to the petitioner. Make one statement.
Yes.
Page, my lord, page 41. Unnecessary 11 is order of rejection, second on litigation. They have my lord
Rejection of?
Act of retrospective promotion to junior ACS cadre.
We are considering similar matters.
Notice in all the notice in this.
Which is the, do you have a copy of that one?
Not.
Issue emergent notice, learned AG accepts notice for the respondents. Call this matter along with WP number. You have it. Got it.
Item 14. Please, my lord. The applicant is for the all service to get all service benefit. So issue decided in the case of Ritanjali.
Others have been extended similar benefit.
Yes, ma'am.
Issue. Right?
The appeal is pending in return.
Appeal is pending.
Yes, ma'am.
That appeal pending before educational tribunal.
No, here one. Writ
Appeal is pending. That matter. Then we have issued notice in all these matters. After that we can.
In this case, appeal is not pending. Only among the children, case, appeal is pending. That is not, that has already been implemented.
In one matter they implemented. Then they have challenged in another matter.
In another.
That is pending.
That is relating.
That is posted on 11th of September, perhaps.
Yes.
15th September. Okay. Issue emergent notice. Learned AG is requested to accept notice for the respondents. First, call this matter in the first week of October, second week of October.
Second week of
October. Yes. Item 15. Do you have another connected matter with you? Do you have a connected matter?
This one. Already posted to after 15th.
After 15th. All after gone on 15th, the second week of October. Yes. Item 15.
Please, Lordship.
Yes, sir.
Here the petitioner is paying for advance promotion benefit from one rank to other upon possessing the higher degree, that is PhD, in terms of Rule 12 of
After Rule 12 say,
Service College Branch Recruitment Rules 2020. Lordship, the relevant rule is at page 27.
did you make representation?
Yes, my lord.
Not considered.
No, my lord. Even it has been forwarded by the Deputy Regional Director to the state government at page 35.
Saying it recommended your case.
My lord, it has been referred, but this has not been considered, your lordship.
Where is your representation?
My representation is at page 36, your lordship. T4/2021.
21.
Prior to that, at page
This is principal. Principal has sent it to regional director.
Regional Director.
Where is your representation?
While I was working as principal in charge, I made this representation, your lordship.
Your application is sent. You are Dr. Manorama Devi.
My lord.
You consider that?
Yes.
Petitioner has scripted his prayer as under. First, next paragraph. Learned counsel for the petitioner submits that his client having made value addition by acquiring a doctoral degree, he is entitled to
Advance promotion benefit.
advance promotion in terms of which rule it is?
Rule 12(1).
In terms of Rule 12 of the Odisha Education Service into bracket College Branch bracket complete recruitment rules 2020. First, he draws attention of the court to letter dated 3/4/2021 through which principal of the institution has forwarded petitioner's claim for grant of said benefit. First, counsel complains that despite all this, the representation of the petitioner has not met its fate till date. And this falls foul of Article 350 of the Constitution. Next paragraph. Learned the AGA, in all fairness, agrees to instruct the answering OP to look into the grievance of the petitioner in a time-bound way and in accordance with law, should all contentions be kept over. First, This is the appreciation. Next one. In the above circumstances, petition is disposed of. First off, time for compliance is 6 weeks. First off, all contentions are kept open. It is open to answering OP, to solicit information, etc., etc. Web copy.
Item 16. May I please, my
Yes.
My lord, the grievance before my lord of the commission is that the authority to opposite party 2 is not issuing the death certificate of his father.
Not
My lord.
issuing the death certificate.
My lord, death certificate of her father.
Is it registered? Whether death is registered?
My lord, that has been registered. The petitioner's father expired on, my lord, 24/2/2018, my lord. That the petitioner has applied through online and offline. That is, my lord, that is, I draw my lord's attention.
All right. Yes.
What is page, my lord?
Now, if your lordship has identical case, your lordship.
No, that was a case where more than a year has lapsed.
Yeah, here 2018. Here it is 2018. Now it's
It says death is registered.
not registered.
My lord, that is registered.
Registered.
Registered, my lord.
Where is registered?
My lord, they under
An exact.
Medical Community Health Center, my lord, and Agua PS.
Is it registered?
My lord, that is the date for 2024 to 2018. I have personally gone to see the register that has been registered, my lord.
Just look into. I'll call this matter next week.
Yes.
Short grievances as to non-issuance of death certificate in respect of a person who died on 24/2/2018. First one. Learned advocate is learned AGA accepts notice on request. First one. Call this matter.
1 week after. It's from Korandi.
No, my lord, this is not Koland, from district Jagatsinghpur.
The death happened in 2018.
Yes.
If it is 2 weeks, how that's going to?
No, I am not contradicting, but the legal hair certificate is necessary for the petitioner.
25, 8. Okay.
Item 17.
Item 7, may I please, your lordship?
Item 17.
Item 17, may I please, your lordship?
Yes, sister.
Your lordship, I'm appearing online, your lordship.
Yes. You are most welcome.
Your lordship, this petitioner is a demonstrator, your lordship, and in this petition, the petitioner is praying for the area of the UGC scale of pay, your lordship, from 1186 to 1196. And also the petitioner is praying for the grant of benefit of RACP, your lordship. Similar matters have been heard by your lordship and notice has been issued. I was praying if it can be tagged along, your lordship.
This learned AG is requested to accept notice for the OPs. Call this will be number
1845 of 2025. 21845.
25. Okay. 7. Yes.
Item 18.
Your lordship.
The petitioner, claiming for regulation of service as Sikha Sahayaka, regular matter also had your lordship.
Admitted
Yes, sir.
or disposed of?
No, lordship.
Admitted.
And
Issue emergent notice, AGA to WhatsApp notice for OPs. Call this matter along with WPN. Next.
Item 19.
Please, my lord. Item 19 and 20, similar order regarding promotional financial benefits.
19 and 20
My lord.
are similar to
Similar to I have given.
Please give me a copy.
issue.
Given the order.
This AGA accepts notice for respondents, OPs. Call this matter along with the sites. Okay.
Item 21.
Still similar. This is a second round, it is similar. The prayer is annex base 10. That I tell increment from 1/1/2004 to 1/1/2016. That Nusan increment they have not paid. And earlier I filed the case. My higher scale was allowed. Then I am challenging annex 7. page 29. Will Lordship turn to page 30, last paragraph. In view of the above facts, the claim of the petitioner to allow 4 notional increment for 1/1/2004.
There's no merit.
No merit. That in 2018, my pay was fixed with 6 increments, my lord. Then, my lord, in 2013, I achieved the higher qualification. Then my scale was revised, and I was received the 10 graduate scale, my lord. Then in 2022, they refixed my salary by excluding that 4 increments, which was fixed in the 2018. That annexer lost.
Take notice. Issue emergent notice, the DG and the concepts notice for OPs. Call in second week of October. Yes.
I will solve it extra.
Yeah, sorry for this.
Item 22.
Yeah. You want to sit and argue? I have no objection. You're not in that one. What is this matter about? You're there. You take notice.
He is not entitled to. He was not considered because he has not filed the documents required for consideration. It is just like a tender matter. There is a condition that he should have completed the 5 years of.
The counsel is not here.
Your Lordship may adjourn.
Call it after 2 weeks to enable counsel for the petitioner to come and argue. Yes.
Item 23.
23, my lord, challenging the order of transfer on the ground of that recommendation of Appellate. Yesterday, my lord, item 32.
Same orders.
Sir. Yesterday,
have you changed all these things, dates and other things?
Oh, my lord, permit me. I can
change everything. Change it. Brother, same order.
I'm supplied.
Same order. Okay. Yes.
Item 24.
May I please yours? Here, what happened, my lord? I purchased a piece of land, my lord. And thereafter,
Agricultural land.
Piece of land, my lord.
Piece of land is agriculture, non-agricultural.
No, this is a homestead property.
Residential plot.
Yes.
Okay.
And to that effect, my lord, a record of right has been created in the name of the present petitioner. And also been paying the taxes before the concerned authorities. So therefore, title coupled with possession, my lord. In the meantime, what happened? The Bhubaneswar Development Authority and the Bhubaneswar Municipal Corporation, my lord, without demarcation, if any improvement or any developmental proposal is on, my lord, then they have to know, first of all, they have to issue notice, thereafter they may proceed with any erection or any demolition or any build. But in the instant case, no notice was issued, my lord. In view of section 408 of the Municipal Corporation Act, prior to take any action, punitive action, they have to take notice, my lord. In the instant case, but no notice was issued.
What they have done now?
Now they have on 7 law 8, they are trying to, my lord, and also to try and dismantle the structure of the present petitioner's house, my lord. Without any notice, nothing, my lord.
All right, you said that twice now. In which year the house was constructed?
Yes.
The structure was built up in which year?
2018.
Where have you stated in the petition?
That structure, when it was erected, that was not there. But I am possessing with my land. But before taking an, there is a if there is a proposal of the government, my lord,
issue. That is, learned AG accept notice for one
government 1456.
1456. Emergent notice to 2 and 3. 2 and 3. First one. Status quo.
No coercive action.
No coercive action shall be taken pursuant to impugn the order.
No, there is no order, my
No
lord.
order.
No.
Coercive action means what?
Because they may immediately take action for demolition.
Yeah, have you sought for interim order?
Yes, yes.
What interim order you
Yes.
sought?
That gracious will be pleased to restrain the opposite parties to take any coercive action against the process of law in the area situated in plot number such and khata number such and such.
Where have they issued notice saying that?
No issue, Lord. That is the question, Lord.
And
Crux
where
of the
is the
matter.
cause of action?
Because without any notice, that is the provision in one.
The order no challenge.
No order has been challenged. That since they are forcibly take action to evict and demolition the house, no, that process is still going on.
They will do it
Without is at any time they can do.
My lords, there cannot be eviction of a person without following due process of law.
Yes.
My lords,
Yes.
provided he has not constructed any unauthorized construction, made some.
Assuming that there is a construction structure.
My lords, I don't say that. My lords, so my humble submission is that unless without following due process of law, government officials cannot enter into his premises.
Recording your submission.
Yes, my lord. If there is any unauthorized construction,
Then
it is open for the authorities to take action.
learned the petitioner is invoking writ jurisdiction of this court, apprehending that the structure erected in his plot may be high-handedly demolished by the OP numbers 2 and 3. Correct?
Yes.
2 and 3. First off. Next paragraph. One learned counsel appearing for the petitioners draws attention to 300 capital A of the Constitution of India and contends that the right to property having been constitutionally guaranteed, the high-handed action is not justified and therefore some protection needs to be afforded to his client. First. Next paragraph. Learned AGA appearing for the first OP number 1, notice to OP number 2 and 3 having been dispensed with, contends that nobody would take any high-handed action against any citizen. If there is any unauthorized construction, due process of law would be adhered to before taking any punitive action. First one. This assurance should satisfy the petitioner. First one. With the above observations, petition is disposed of. First one. A registry to send a copy of this order to OP numbers 2 and 3 by speed post immediately. Parties to act upon web copy. It's a good thing actually. There's a famous judgment of Justice Venkatachalaya, the great M.N. Venkatachalaya. Yes.
Item 25.
Item 25, may I please your lordship. Lordship, the petitioner is praying for sanction of the family pension, your lordship.
Family pension?
Yes, your lordship. Lordship, the husband of the petitioner has
died in which year? Husband on which year?
Lordship, 1979.
1979?
Yes, your lordship. During that period of time...
Yes, you were not born in 1979. You were not.
Lordship, at that point of time, OA...
You were trying to wait for the birth of you. You are becoming a lawyer. And then she is complaining family pension. When Did you make any application for a grant of family pension?
Yes, Your Lordship. I have made previously, I have taken liberty to approach the authorities. Also, there is a grievance petition before the collector, Your Lordship.
Brother, if husband has died in 1979, and if the widow he has applied for a family pension.
Lordship, that
In fact, it was recommended to controller of accounts.
Correct.
They sought for opinion of government. That was torn down.
At least during the lifetime of that widow, these things should happen.
No, that was considered earlier. And she's not entitled to. Let notice go, will file.
Lordship, that point of time, there was an act was introduced. Under such act, 2 other persons also granted family pension that is under Annexure 2 series, Your Lordship.
Your client is not.
Yes, Your Lordship. That point of time, I was denied. And later on.
Miss so and so, who argued elegantly and made out the case for issuance of emergent notice. First up, learned AGA is requested to accept notice for the respondents. First up, since claim relates to family pension, in the second week of October. Yeah.
Item 26.
Yes, you are.
Yes, Your Lordship.
Yeah.
My Lord, I am challenging Annexure 6 and 8.
Yes, ma'am.
Annexure 6 is the cancellation of my promotion. Annexure 8, denial of my to give me promotion with retrospective effect. My Lord, I was appointed in 87. In course of 87, in course of time, I was promoted to the post of section officer. Thereafter, by Annexure 1, I was kept in charge of administrative officer. In 2021.
You were placed in the charge of administrative office, but that's not a promotion.
No, it cannot. I continued there for more than 2 years. So I have, on the last date of my superannuation, they have given me promotion.
To the post which you were holding on
that. Yes. Thereafter, I have claimed for my benefit. So they denied it, for which I approached them, and I approached this honorable court. This honorable court directed me to once again approach them, that I have approached. So Annexure 8, they have passed the order.
What they say?
They say that I am not entitled to. Your Lordship may kindly turn to page.
Had they given you promotion?
Yes, that was my Lord in as per order issued Annexure 5.
Annexure 5.
I have joined. Annexure 5 I have joined.
Read Annexure 5.
Annexure 5, before it, Your Lordship may kindly turn to Annexure 4. Annexure 4, page 17. Pursuant to the order passed by the Vice Chancellor through WhatsApp message so and so, followed by her kind order in this regard on dated so and so.
On ad hoc basis?
Yes, on ad hoc basis. And I joined on the very day. Superannuated on the very day. So my case is that since I was put in the charge for about more than 2 years, and there is a vacancy, so I should have been given the
promotion
benefit. Yes. That is the case before Your Lordship. And apart from it, Your Lordship may kindly turn to page 22.
Cancel the office order.
Yes. They have
2023.
Yes. Hide Annexure 6, they cancel. Annexure denied.
No notice was given to you?
No.
You were not heard in the matter?
Because by that time I was retired.
Issue emergent notice. AGA is not a party. University. In addition to taking usual steps, petitioner to serve a copy of the petition on the learned panel advocates.
No, my Lord, notice may be issued because there is a panel advocates.
I have issued notice also. Plus, I am permitting you to serve a copy on the panel advocate so that early we can do that. In addition to taking usual steps, so I exercise.
Okay.
Please. Item 27.
My lord, I filed amendment petition. Last order, my lord, may kindly see. The order of dismissal has been passed after my filing. The order of dismissal has been.
You have filed application.
My lord, I have filed that application.
Calling that order.
My lord.
That order is appellable, my lord.
Is it appealable order?
My lord, the order of dismissal now, this was the.
Yeah, it's an appealable order before the tribunal.
No,
Departmental authority.
For the director.
It's, my lord, question is.
Appealable before whom?
Appealable to the government.
Government. You file appeal. I will direct the government to dispose of the appeal within 3 months. Alright?
My lord, may I make one submission? This, from 2019, the litigation was being fought out here before these honorable courts. It was allowed in my favor. For some technicalities, writ appeal, again, further order in my favor was passed. That was not taken care of in appropriate spirit of the order of this honorable court, and now the order of dismissal has come. So that is now under challenge before my lords.
No, but it's a statutorily appealable. It is appealable. Therefore, you take up all these contentions in the appeal. I will permit you within 2 weeks. Within 8 weeks, they will dispose of the appeal. All right. Petitioner has scripted the original prayer as under. First time. Next paragraph. Now an application is moved seeking to add additional prayer for laying a challenge to the dismissal order dated
28/7/25.
28/7/20 by way of amendment under the shadow of this court's order dated, go to my order, dated 5/8/2025. First time. Next paragraph. Learned AGA, on request appearing for the respondent, points out that the order of dismissal is statutorily appealable before the government. Under which provision?
My lords.
Under terms of which act? Which act?
He is the expert.
Not the book, because he since
appealable.
Dismissal.
And therefore,
23.
petitioner should be relegated to statutory, relegated to the alternate and equally efficacious remedy. First, learned counsel for the petitioner is agreeable to this proposal, provided that liberty is reserved to him to file the appeal within 2 weeks, coupled with a direction to the government to dispose of the appeal within a period of, within an outer limit of 8 weeks. All right? This is a happy thing to happen in writ jurisdiction. Next paragraph. In the above circumstances, if petition is disposed of, reserving liberty to the petitioner to avail the alternate remedy of appeal within 2 weeks, reckon from this day. And if appeal is filed, the appellate authority shall hear and dispose of within an outer limit of 8 weeks. First, all contentions of the parties are kept. Dispose of the appeal and inform result of such disposal to the petitioner within an outer limit of 8 weeks. First, all contentions of the parties are kept.
My lord, there is little confusion here.
Government. Director.
Jurisdictional.
Yes.
Item 28.
Please.
The petitioner
Item 28.
But I am for the opposite party number.
The petitioner.
What is this matter Oh, after notice matters.
Yeah. Counter is filed.
Huh?
We have filed counter.
Let's argue.
Lordship, may kindly see the.
No, is for the opposite, another opposite party.
I am the agreed
petitioner is not there.
Oh, yes, petitioner is not there. That's true.
Let him come. Post this matter in third week of September to enable counsel for the petitioner to come.
Short date may be given because why it is.
Interim order is there.
Interim is there. Therefore, my lord, we are unable to get that salary and all these things. We are in starvation now because we are the peon and working in the deaf and dumb school.
In the first week of September.
My lords, next item, your lordship granted 2 weeks time, otherwise it will be forfeited, right will be forfeited. We'll file application with counter for reconsideration.
When are you retired, my lord, to get the benefit, what has been extended to the others?
Within a week.
Within a week you are doing. Counsel for the AGA. Do you agree that let him file instead of filing application, this, that, etc. Oral application he will consider it. So that let him file the objections.
My learned friend is intelligent. My learned friend is intelligent than me.
No.
I started.
You are more intelligent.
You see, he is intelligent than you. Then he must be more intelligent than me. This court order, take.
My lord, normally.
Where is forfeiture? No, forfeiture order is not.
No, my lord. Next item, I am confused.
Counsel, the learned AGA seeks 1 week for filing count. First off, with this proposal, petitioner is agreeable. Call him first week of September.
This is the matter. Next item.
Next item. Next item, who he wants to file counter.
My lord.
No, my lord. The last occasion, your lordship were about to dispose and dictate the order. Only simply, this is a very silly matter, my lord. In my leave account, I have the leave in my credit leave account. I have taken 6 days leave and the next day was the holiday. That 80 days was not sanctioned since last 3 years and I am not getting the increment. And lastly, they have treated as a EOL. My lord, as per the Odisha leave rules, my lord, when no other leaves are available in the leave account, then it can be EOL. That means no work, no pay.
EOL means what?
Extraordinary leave.
Extraordinary leave.
My lord, that
where
is
you will not get the salary.
Not get the salary, and that period will be also not counted.
One week we grant. You want
and two adjournments
may find fault with him.
This is a small matter. I am not getting the increment.
Good matter.
No, I am not getting increment on that ground since 2022. That is why your lordship on the last occasion about to dispose.
Last order. Learned counsel appearing for the state seeks short accommodation to file counter. First off, this is vehemently opposed by counsel for the petitioner in the light of order dated 31/7/2025, which reads as under next paragraph. Learned AGA makes an oral application to relax no forfeiture, since matter involves certain arguable points, and seeks a short accommodation to file the counter first time. There is a force in the submission of the AGA first time. Therefore, 1 week is granted to file the counter. Call this matter after 2 weeks. A copy of counter to be served on the
date maybe.
Well in advance. It will come in 2025 next.
Item 31.
Increment not sanctioned. That is why.
Pardon to interrupt, my lord. Item 22. It has been. I was not present at the time of call.
22.
Yes, ma'am.
Yes, we wait till 2 o'clock.
I was held up in another court. So
therefore, I will take up after 2. Not
oh, bless me. After 2.
May I please,
my lord, this.
22. Yes.
May I please, Madam? Madam, this is a matter, Madam. The present petition is a PGT teacher in the Kendriya Vidyalaya, Madam. There is an allegation of sexual harassment by a girl student, Madam. Then after we.
They are against a girl student.
No, against the teacher, Madam. Against the
Against the teacher.
Against the teacher.
But the complaint was by
the girl, father of the girl child, Madam. So without any preliminary investigation, the principal handed over this matter to the police, Madam. Then after the present petitioner was arrested and later on he was bailed out, Madam. But simultaneously, a criminal proceeding and a departmental proceeding was there, Madam. In the departmental proceeding, the present petitioner is exonerated and the allegation has already been set aside, Madam. Now the criminal proceeding is going on when the present petitioner asking for the document, to prove himself innocent in the criminal court, my lord, they are not providing the documents, my lord.
You can make an application to the criminal court and get him summoned.
My lord, may I permit it?
1 second, we are answering your term may not come at all. Have to wait.
So, my lord, they are not giving the
they are not
RTA, my lord. RTA.
Can you produce RTA documents in the criminal court?
No, but it is necessary, my lord, because the videographs, my lord, which was on that day, that footage, on that day, this allegation has come.
You make it to the criminal court, summon these documents. Court has got enormous power.
We have done so, but beside my lord, when we are asking, they are not providing. That's why I have to
make an application, they will provide. You summon the record from the criminal court.
I have suggested also to my friend out of court. That is the procedure. And only that is jurisdiction. I have issued this. He has a wrong before your lordship has a wrong jurisdiction. He has filed before the Central Administrative Tribunal. Because he is a Kendriya employee, as per the central government India notification dated 30/12/1998, all the central government employees of the Kendriya Vidyalaya Sangathan has to challenge with the central concerned central CAT, and thereafter this court is this is the service related.
Not a service. No, madam.
Not a service.
No, Mr.
He is not particular B. He has exonerated. Any document for the departmental inquiry is sought for, that to be for the central administration, not for before the High Court.
Wrong. It is not a service disputed.
Yes.
He wants to have the defense before the criminal court, and in support of that, he wants documents from your side. That is not a service dispute at all.
Madam.
Assume that he was not an employee.
Employee of the Kendriya Vidyalaya Sangathan.
No, assume. He is not an employee of the
Started department under the Article 8 B of the Kendriya Vidyalaya Act.
Then what?
Why can't
and that document he wants.
To permit this judge to argue. It's not that there are judgments. There are judgments.
There is also judgment.
There are judgments.
I have with the judgment of the Punjab and Haryana, that is regarding jurisdiction also the service related.
That is not this facts of this case are not there in that Punjab Haryana High Court judgment. I have read that judgment. There is a judgment on Allahabad High Court holding that disputes of the kind do not partake the character of service disputes. They do not fit into Section 19 of Administrative Tribunals Act 95.
Any service related?
This not service related at all. It is.
That is
anyway. Now we'll anyway. Wasted time. The short grievance of the petitioner is as to non-supply of certain documents and material in terms of his RTI application.
Under Annexure 3.
Copy whereof avails at Annexure 3. First. Next paragraph. Learned counsel for the petitioner argues that in a sexual harassment related case, a disciplinary proceedings having been held, his client emerged victorious, semicolon. However, he has facing a criminal trial in relation to the very incident itself, and therefore he is in need of certain documents and material for prosecution of effective defense in the said criminal case. Criminal case number?
That is valid, that FIR, the date and time of FIR.
Why the FIR number?
Yes, I'm. Not 0011. FIR number 0211.
211 of
Dated 30th November 2023.
30/11/2023.
In the police station of that is.
Which police station? How you
some Pali mallet, that is not visible mallet. There is
in the jurisdictional police station.
Yes.
First, next part. Learned panel counsel appearing for the
Kendriya Vidyalaya Sangathan.
OPs.
All OPs.
OPs. Contending that matter has the trappings of a service dispute, and therefore petitioner should go before the Central Administrative Tribunal by making an original application as provided under Section 19 of the Administrative Tribunals Act 1985. In the light of Apex Court decision in which is that 97 judgment after Sampath Kumar.
That is the L.
Chandra Kumar versus Union of India. 1997 SC.
L. Chandra Kumar.
He also points out that it is open to the petitioner to move an appropriate application before the jurisdictional criminal court for summoning of the records from the OPs, and therefore this court should not grant indulgence. Next paragraph. One sentence again. This court agrees with the submission of learned panel counsel. The second submission of the learned panel counsel, although not first one. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to move the criminal court by an appropriate application. And if that is moved, the criminal court is requested to hear and dispose of the same before taking up the main matter. First,
high level.
all petitions kept open.
Modern certificate copy.
Yes, that's web copy to be acted upon.
High level.
I believe your lordship.
Yes.
In this case, my lord, there are two revenue villages, my lord, in the district of Keonjhar, my lord, adjacent to each other.
Two villages.
Two villages, revenue villages. No, one village, namely Motor Gadia, my lord, lordship, kindly have a glance. The page 15 of the brief petition, my lord. 15, my lord. This is a Mauja Motor Gadia at the top of the Arwat.
All right. What you want? There are two villages.
Two villages.
There is one famous book by The Tale of Two Cities by David Copperfield.
My lord. Here, my lord, what happened, my lord? In the next page, my lord, page 16, my lord. Over the plot number 245, my lord, left side of the document, my lord. 245, 20 decimal, my lord. Over which, my lord, a primary school, government primary school is existing, my lord.
On 245, plot number.
245, plot number. Government primary school is existing, my lord. Well, what happened, my lord? Let's see, for a moment, my lord, kindly see the page 13, my lord. 13. This is the village name Dharmapur. That is, my lord.
This another village.
Another village, Dharmapur. Adjacent village.
What is your prayer?
My prayer, my lord, the a primary school existing over the plot number 245 of Motorgadia Revenue Village, my lord, against which, my lord, government already sanctioned 25 lakhs some odd, my lord, for construction, my lord, of the school, my lord.
They have not constructed.
They have constructed. What happened, my lord? Annexure 5 lots you can have. Page 19.
Are you a student?
No, my lord. I am the villagers of village of my lord, Dharmapur, the adjacent village.
Opposing the construction.
Opposing construction.
Opposing the construction.
Because
School.
Because, my lord,
Wine shop I can understand.
lots of, I'm coming to that point, my lord. Because, my lord, this is the adjacent village. In respect of Dharampur Mauja, my lord, Dharampur village, there is a plot number 463 dismills of land that is adjacent to the school, adjacent school of Motorgadia. But this is land was reserved for school Hatta of Dharampur.
Now they are putting up construction for the school only.
And land,
No.
land belongs to government.
Their own
Land belongs to government. Government land.
That is the land of Dharampur Mauja.
Not Dharampur.
Sir, that does not belong to you.
Not
How you are
we are
concerned?
the
Let the
villagers.
government build 100 schools. How you are concerned?
Yes. What happened, my lord? They should not encroach upon the land of Dharmapur Mauja, my lord. Dharmapur Mauja, the land
That Dharmapur Mauja land belongs to whom?
belongs to the Dharmapur village, my lord.
Village means who?
Village means, my lord,
Government.
there is a, my lord, boundary line between the two villages.
How? Is there any the buildings are constructed
My lord.
on two continents,
Hmm.
Constantinople,
My lord.
Istanbul, earlier name. The structures are constructed on two continents.
Yes.
Why not two villages?
Lordship. Because that is, my lord, they are, my lord, what happens? No, what I am just convincing your lordship, my lord. The petitioners are the villagers of Dharampur, my lord.
How you are concerned with this?
Because the lordship, for a moment, my lord, I am satisfying lordship, my lord. My lord, what happened? Dharmapur Mauja people, my lord, they are the approaching for lordship, my lord, with submission that the Dharampur Mauja land has been illegally encroached upon.
Who is illegally? Government is the owner of all lands.
Government only started sanction money for construction of boundary of the primary school, not of Dharmapur, my lord.
I am imposing 50,000.
Well, lordship can have a glance.
I have heard you. I cannot go on hurrying.
There is a quarrel between the two villages.
Let them quarrel. What we can do? Government wants to build.
Because of police also interfere. Lordship can have a glance, my lord. Because, my lord, there is no school at all in the Dharampur village.
You ask one more school. That is not your case.
There is no land, my lord, for Dharampur, for establishment of school at Dharampur.
Let you make application for establishment of school. If it were to be wine shop, I would have understood.
But there is no. Yes. But what happened? There is no land, my lord. No land. This is the only land, my lord, of Dharampur.
Petitioner. I have heard you. I will not hear you more than this. There is a time limit for hearing all matters.
Yes.
We cannot hear you till cows come.
I am submitting for lordship. What is
submitted and I have heard it.
What is they are encroaching upon the land of the village of Dharampur, my lord.
Petition.
My submission will be recorded, my lord.
Petition dismissed with a cost of rupees 5,000. Origins to follow. Okay.
I
have 5 days.
They are suffering a lot, my lord.
5 days to give my reasons by virtue of the apex court decision. I did not give you reason right now. 5 days apex court has granted us to give reasons. It will come in the evening today.
It is the right of the people of the my lord. Look into the brief, my lord. Then my lord, your chief pass order, my lord.
Yes,
my lord. They will suffer, my lord. So there is no land at all, my lord.
You have said, I have recorded, don't waste time of the court. Cost will increase. Cost will increase.
I am permitted to withdraw, my lord, or approach to the appropriate authority, my lord.
Petition counsel for the petitioner having argued the matter unnecessarily for a longer time than usual. Come on. He is reluctantly granted leave to withdraw the petition. Petition disposed of accordingly. Don't waste of the time. But wherever matter is, no liberty is granted to litigate on this subject. Yes, next.
Item 33.
Appointment of case
3 minutes. I am appearing for opposite but now 3 and 4 minutes. I am filing counter minutes today.
Counter?
Yes, sir.
Have you served the copy?
Yes, I have, sir.
Just now I received the copy. Well, it's me. Just because of the fact that it's a guest faculty lecturer, the lecturer tenure is 10 months only.
Now remaining only 10 months.
Only 9 months.
So itself is 9 months.
The tenure is 10 months.
Yes,
Now 1 month is going to expire.
When it is going to expire?
April 2026 minutes.
April 26
Plus.
Then we will call this matter in October. Call this matter in October.
Guest faculty lecturer, I have stood fast in the interview. I could not get appointed.
Anyway, October will finish up. No, there is 25 matters. There are many old matters. Many of you spend unnecessarily time of court. What I should do? If you use time correctly, because we have to ration the time. This is public time. If everybody goes on telling the cock and bull story, how the people will get justice?
Previous matter I understood, my lord, but
previous matter, not previous matter. But there were many other matters I have been seeing. People spend a lot of time.
I appreciate my predicament.
Appreciated. Predicament appreciated. Call this matter in October. Second week. Yes.
Item 34.
Prejudice, my lord, 10 months tenure is total of mine.
We'll consider in 26 April.
But it is you are in August 25, my
lord. First week of September.
One submission.
Second week of September. Yes.
Shall I file in court or in registry?
You file in the registry because they have to verify. Yes. Next.
Name is not correctly typed. May I pray?
Registry to type
yes.
name of the consent for the OP as give that name.
Yes, sir. Yeah. Deeply published.
Item 34, my lord. Pass over.
Sir, item 34. The lordship has directed on a matter was before your lordship on 29/7.
Check.
I have not received the instruction. I pay short accommodation.
Short accommodation is calling the second week of September. The request of learned AG. See, one request I will make you. If you make out a good case, I never deny relief at all. You take it because I understand nobody comes to court as a luxury. Inevitably, they come to court because they cannot get the work done there. They're all maybe poor people, disabled people. Therefore, don't waste time. Make best use of the court. This is for you only. Is it not? Orders I do not carry to Bangalore, nor your fees.
Item 35.
Item 35, before my honored senior starts making his submission, I today have for opposite party number 5 the principal in charge.
When do you want?
I want some time and the copy of the writ petition may be solved on me.
Give him.
Yes. Because notice has not been issued to the OP number 5. Today is appearing. There is appearing.
Issue notice to OP number 5. Others notice issued.
Others notices.
Government P number 5. Call this matter in the second week of September. In the meanwhile, these pleadings may be completed.
Interim order continue.
Interim order. You have interim order?
Yes.
Interim order is there. All in the last week of October. Yes.
All this
interim order to continue. Okay.
Item 36.
Grateful.
Item 36. There is a inadvertent mistake that received matter which is to be listed along with this number. Wrongly, the same number has been typed. This number will be
call this matter
20596.
WP 20596 of
2025.
After deleting WP,
same number has been typed.
Same number WP. After deleting same number.
This is all the matter posted to 3rd week of September.
Anyway, along with that, it will.
Along with that number I have given.
Next.
Item 37.
Yes, 37.
37 minutes.
Yeah.
This last order may kindly be seen, that is dated 18/7. 18/7/2025.
Cost of rupees 1,000.
No, that has been paid.
Paid.
That has been paid. I have given the
copies also, my lord. I have got that copy, my lord. On this.
Yes.
Already I have. Page on 23/7/2025, my lord. And thereafter, my lord, this dispute involved and additional standing counsel is directed to provide the order issued by the department showing the creation of the post of the lecturer in the logic and philosophy of the City Memorial College, my lord.
Yeah.
That we have to submit, my lord.
When are you submitting?
But I pray 10 days time, my lord. Already it has been duly communicated to the authority concerned. I pray a week or 10 days time, my lord.
AGA submit that he has remitted the cost of rupees 1,000 as directed by coordinate bench by the order
23/7, my lord.
18/7/2025. And he needs a short accommodation to comply with the paragraph, order 8.
Dated 18/7/2020.
Order dated short to provide order issued by the department showing creation of post of lecturer in logic and philosophy in Netaji Subhash Chandra Bose Memorial City College, Cuttack. First off, 2 weeks granted finally for compliance, failing which heavy costs may be levied on the concerned officer on the next date of hearing. Okay. Yes.
Item 38.
2 weeks, madam.
2 weeks.
Please, your lordship. My lord,
Yes.
I am sorry to pray for an argument, my lord, but some documents of my file is missing, my lord.
Your documents are missing.
My lord.
Second week of September, can we have this? September 2nd week.
Within 1 week, yeah.
Within 1 week. We have a difficulty within 1 week. You have copies?
I am for the respondents, one of the respondents. Lordship, I pray that Lordship kindly have a glance at the order dated 18/10/2019. Yes.
Probably if you were dismissed, my lord.
If you
I
were
have filed
dismissed.
an application for
Restoration.
My lord.
Restoration.
That is pending, though.
CMAPL 406.
Dismissed for non-prosecution.
No, my lord.
Merits.
On merits.
Where is that?
Your Lordship kindly have a glance on dated 18/10/2019. In view of the order dated 15/10/2019 passed in FU number 430 of 2012, in which the appeals filed by the state of Odisha have been allowed, considering decision of the Honorable Supreme Court passed in civil appeal number such and such arising of the state of Odisha and other Anup Kumar Senapati disposed of on 16/9/2019, the present appeal deserves to be dismissed. Accordingly, the appeal stands dismissed. All connected miscases /IAs are also disposed of. It is made clear that if appellant is agreed by this, it will be open for him to file application within a period of 30 days from today for revival of this appeal. So the order has been passed on 18/10/2019.
Yes.
So
when he made the application.
That is not available in my file, my lord. I'm sorry, my lord.
He wants file, na?
So
call in the second week of September at the request of learned counsel for the appellate. Applicant. Yeah. Final. Yeah.
And that CMAPL copy also be served upon us.
You will serve a copy of the. Okay. Yes.
Item 39.
Because
39, I am appearing for the appellant.
yes, sir.
Lordship, I pray for a short date, your Lordship.
Well, the interim order is operating against me, and because of the interim order, I am not able to get granted it.
You are not able to get grant in it.
Yes.
2023 matter.
Lordship,
Will have
18 matter. 18 matter. 2018 matter. 18 matter.
Lordship, so short adjournment. Lordship, this matter has come up and not able to get the latest instruction, whether he is still working in that college or not. Let's.
Well, this is an interstate dispute between the.
We'll have it in the second week of September. Finally,
Lordship, may I pray let it be on 8th or 9th, Your Lordship?
all right. That day you have to argue the matter.
Lordship.
Yes.
As a last chance, Your
Call this matter on 9th of September. 9th of September.
9th of September.
10th of September we will have that.
Yes. Lordship, 10th, 11th. Lordship, 10th and 11th, it will be.
All right, 9th of September. At the request of Learned Counsel appearing for the
Appellate.
petition. Appellates.
Lordship.
Appellates. Final. Not talking.
Item 40.
Yes. Well, virtually this is a covered case. Well, on last occasion, Your Lordship directed the.
Pardon, Lordship, interim order to extend it till.
Then, interim order to continue till 9th.
Lordship.
Well, this is a covered matter.
Yeah.
On last occasion, Your Lordship directed me to serve a copy of that judgment. I have already served a copy of that judgment. Well, this is a
judgment again.
Girls High School case. But this is a case of 100 Girls High School. So far as 100 Girls High Schools are concerned, those schools became eligible to receive effect from 1694 as per the granted order of 1994. But those schools were not notified from 1994.
Why you are your client who is standing? Ask him to sit down.
No, my lord.
Sit down, sit down. Yeah.
He is not my client.
Yeah.
My lord, thereafter, the state government brought the granted order of 2004, which had undergone amendment in 2007. So therefore, all these 100 girls' high schools, they were notified to receive granted aid with effect from 1/6/1994 with annual increments and other service benefits. But they will get block grant, 100% block grant from 22/9/2007.
What is difference between block grant and grant in aid?
Well, virtually there is, well, so far as granting aid is concerned, my lord, as provided under the granting aid order of 1994, my lord, a college gets granted aid at the rate of 1/3 on completion of 5 years of service, on completion of 5 years from the date of concurrence, then after 7 years from the date of concurrence at the rate of 2/3, and full after 9 years. My lord, so far as granting aid, after the granting aid order of 1994 was repealed, and
2007 was brought in.
No. 2004 came into force.
Correct.
Well, both for schools and also for colleges. And different granting aid orders, 2008, 2009, 2014, like that. So far as the present case is concerned, these 110 girls' high schools, they were in fact eligible to receive granted aid from the state government with effect from 1/6/1994 as per para 7 of the granted aid order of 1994. In the approval order also, it has been clearly mentioned that they are eligible from 1/6/94. They will get annual increments from that date. The employees of that institution, they will get annual increments from that date, but they will get 100% block grant from 2007. Out of these 100 girls' high schools, some schools, 20-30 schools, they approached the State Education Tribunal. They succeeded in the tribunal. They also succeeded in this Honorable Court in the appeal. Thereafter, the matter went to the Honorable Apex Court. The Honorable Apex Court also upheld or confirmed those judgments, and they got the benefit.
Have you got that copy of the order?
Not that copy, but I have made it, but it is missing.
I will supply another copy.
I will supply another.
Yes.
We'll call this matter in the second week of, on that date itself. 9.
Yes.
9.
Just look into.
Yeah, exactly.
If it is covered.
Directly covered.
Yes. Yes.
Item 41.
Your Lordship, I was appointed in the year 1987.
41.
Under Annexure
Are you three? Government AGA ready?
No. I have to take further instruction.
Which place you are coming from?
I'm from Nirakapur, sir.
How many kilometers?
Around 80 kilometers.
80 kilometers. Yeah. Which Mr. AGA choose a date, on that day you have to argue because he is a party in person. You cannot ask him to
Next, this 11th, it will be.
Call this matter on 11/9/2025. First of all, this date is chosen by President AGA himself to argue the matter, since party in person happens to be the petitioner. Okay. On 11/9. Okay. If it reaches, we will take up.
But your lordship, this is a case of higher education department.
Higher education department.
I'm an employee under higher education department. Accordingly, the AGA.
That we are considering.
Just he is alerting to get all information.
As if he is thinking that somebody else will be there for the hazard. No, it's okay. No.
He will come.
That we will take care of.
Yes.
Item 42.
My Lord, I am appearing on behalf of Mr. Rautre. Senior counsel Mr. Rautre is placed badly today. This matter may come up next week.
My Lord, in this case, I am for the respondents.
Your friend one.
Yes, that only one point they have taken. They have filed an affidavit that they don't have the power. We have succeeded in the tribunal. The money has been withheld by the governing body. What has been sanctioned by the government, the granted in favor of us, has been withheld. That is why they have deposited. So once there is no governing body, this petition may not be maintainable. That is the only point they have admitted.
Yes, that is. On what's this matter on 24th? This 24th?
Again.
Next week.
Yes.
24th.
Item 43.
September.
No.
But 24th, sorry. Yes, 24th.
25th.
No, 21st. Because it's 21st.
First.
Normally, Mallard says that
these matters are taken on Thursday.
Thursday, yes.
So,
21st or it is
17. The September 11. All right.
11.
Okay. At the request of learned counsel appearing for the respondent.
No, appellate.
Appellate. She is appellate. Okay. Yes.
Item 43.
43, the respondent on behalf of Mr. Rautre.
43 also you want time? Yes, same ground.
It may come up for hearing on the next week. Next week.
Next week. Same day we'll have that. Same day.
Obliged.
At the request.
Lord, in 43, that we have directed to pay rupees 1,000 to the Bar Association.
Have you paid that?
We have paid and receipt is there. I can.
AGA submits that in terms of coordinate bench order.
Yes, ma'am.
Coordinate bench order. Take out the
This is order dated 25/7, ma'am.
25/7/25, comma. Cost of rupees 1,000 is remitted to High Court Bar Association Welfare. The same is noted.
Much obliged.
Item 44.
44 may prefer an adjournment for next week.
In the call on 18/9. On request. Yes.
Item 45.
May I please?
Yes.
I have challenged the judgment and order of the State Education Tribunal passed on 26/2024. 26/2024. That is under Annexure 23.
Who appears for the opposite party? State. Is it ready, Mr. Navanti? Are you ready in the matter?
No, my lord.
Please tell the beginning.
Very small point is involved.
11/9. Same day. So that whole day you can be in this courthouse.
I am ready. In all the cases, I am ready.
Yes.
Majority case also belongs to my learned senior. And he will enlighten about all the Education Act.
Item 47.
Yes.
47. 47 में परिवहन नहीं.
Again,
Are you ready?
47 मोटे आलोक नहीं. 47 is allotted to some
Other
other law
education.
officers.
On 18/9 we'll have it.
89.
Yes. This date is chosen by learned AG. Okay.
Item 48.
Yeah.
Because this FO has been filed by the appellant
Yes.
against the order of our state educational tribunal. He was before the state educational tribunal seeking directions to the state opposite parties to approve his service, and it is granted under GI order 2009. That prayer having been denied, having been dismissed, he has approved this honorable court. The case of the petition in brief is that he was appointed as a lecturer in English.
Mr. Mohanty, ready in the matter?
No, Mr. Rai is there.
Right. Ready in the matter? Hey, why you are not getting ready in all these matters? These are all educational matters.
Yes,
Education department.
The education matters. And
He
the
wants time. Let it come. Yes. Call on 18. 89. This date is chosen by the learned AG. Yes.
Item 49.
49 minutes. There is a notice to respondent 5 return.
Take first steps.
I will take first steps in the correct address.
First steps along with correct address to be taken within 4 working days.
My lord,
Within 1 week.
one week.
Within 1 week.
I guess the respondent 5 only.
As against respondent.
Interim order to continue.
Interim order to continue.
Okay.
Okay. Call in October. Second week. Yes.
Item 50.
item 50 is a fresh matter. Sir, my lord, the grantinate case is pending before the State Education Tribunal. During the pendency of the grantinate case, I filed an application for amendment before the tribunal, which is permissible under the tribunal rules. The learned tribunal rejected my application for amendment that it will change the nature and character of the case. My prayer for amendment.
What was your main prayer?
My main prayer was to release grantinate. My main prayer is to release grantinate as per the grantinate order of 1994 by approving my appointment against the post of additional section teacher. Since grantinate order of 94 has already been repealed by virtue of grantinate order of 2004, I made an alternative prayer besides that prayer, that alternatively I may be allowed to get grantinate as per the grantinate order of 2004. The tribunal has held that since it was not the main prayer, so that prayer cannot be entertained.
What kind of reasoning is this? It is absolutely in consonance itself.
Yes.
We'll allow this petition. Amendment needs to be allowed. You take up whatever contentions you want to.
Yes, my lord.
In opposition to the amended
The Lordship's direction, so far the remand order is concerned, my lord. That is specific to dispose of the
correct.
During time, my lord.
Correct.
And that,
Did it prohibit amendment?
No.
No, my lord.
You were in the earlier round of litigation in GIA 423.
423.
The short grievance of the petition appellant is against the order dated 2/7/2025 made by
No, my lord. Yes.
the State Education Tribunal Bhubaneswar, whereby his application for amendment of prayer mood in GIA case number 423 of 2014 has been negative on the ground that the amendment if followed would change the nature of case. Kindly be seated. Learned counsel for the appellant draws attention of the court to the main prayer in the GIA, wherein challenge is to the denial of grant in aid. In terms of the GIA Code 2004,
GIA Order 1994.
GIA Order 1994. First one. In the subject application, he wanted to introduce the prayer for
alternative prayer for getting granted aid as per the granted aid order of 2004. In addition to the main
alternative prayer for a direction to accord grant in aid under the grant in aid code 2000
granted aid order 2004.
Grant in aid order 2004, which had repealed 1994 GIA order. First stop. Next paragraph. Learned counsel for the petitioner submits that there is a proximity and contiguity between the original prayer and the prayer sought to be introduced by way of amendment, and therefore the version of the court, the tribunal, that if amendment is allowed, it would change the very nature of GIA. It is unsustainable. First stop. Next paragraph. Please be seated. Learned ASC appearing for the OPs opposes the petition, making submission in justification of the impugned order and the reasons on which it has been structured. First off, he tells that where the amendment is belated or it changes the nature of the main case, comma, request for such amendments are not accorded. First off, next one, having heard the learned counsel for the parties and having reviewed the appeal papers, this court is inclined to allow the subject application for amendment in as much as the main prayer in the before the tribunal and the additional prayer sought to be introduced by way of amendment have contiguity and proximity. Semicolon. In any case, the reasoning of the tribunal that amendment would change the nature of the case is very difficult to agree with. First off. Next paragraph. In the above circumstances, this appeal is allowed and impugned order of the tribunal is settled not. Semicolon. The state to allow the amendment application as sought for and dispose of the main case, that is GIA case number 423 of 2014 within an outer limit of 9 months. Yes. First of all contentions of the parties are kept over.
The second matter is also same. The impugned order is under Annexure 14. Same.
GIA is no different.
GIA case number is different. That is put double up.
Same. Okay. No. Yes, this one.
Urgent certificate.
Okay. Web copy to be acted up.
Yes.
Yes, 51.
I beg excuse, my lord. Item 34. So
34.
Passover matter, my lord.
Give 34. Can we come in the afternoon?
After recess, yes, my lord.
I will come back, or we'll finish up this matter.
Item 22 is there.
22 is there. We told him to come at 2 now.
Yes.
Yeah. We'll come in the afternoon. There is one more case.
Yes.
Are you free in the afternoon?
After this, I can, my lord.
Huh?
After this next matter, one more matter is.
One more matter is there, no? 51.
22 is.
22 is there. 22, we told him to come at 2. I did not know that list should be exhausted and so forth. So, I will come in the afternoon at least. Huh?
Let me try calling so that your lordship will.
Very well. Most welcome. No issue. Yes, brother.
My lord, here also my application for amendment was rejected by the Law and Tribunal. I filed a GIA case before the Law and Tribunal claiming approval against the post of peon first and release of block grant as per granting order 2008. As per granting order 2008.
You approval to peon's post
as per granting order 2008.
The order 2008.
My lord. My GIA case was rejected on 11/11/2019 on the basis of a counter filed by the state government. Even without serving the copy of the counter, my case was rejected. I approached this honorable court by filing a FAO challenging the order of the Law and Tribunal
and remanded.
Matter was remanded. During pendency of the FAO before this honorable court, after matter was dismissed, 11/11/19, on December 2019, another person's appointment was approved against the same post, my lord. After remand of the matter by this honorable court, I filed an application for amendment. Since matter has been remanded for re-hearing of the case afresh, I filed an application, and since in between approval has been made in favor of the person, I made him party. I want to make him a party and also challenging his approval. Unless that goes, I cannot get the benefit because one post, two claimants are there. Law and Tribunal rejected my application on the ground. What is the occasion why you have not brought this matter to notice of this honorable court? Though the matter was not relating before this honorable court a similar footing, my application was rejected with one paragraph, say on the basis of the counter earlier. That was remanded. So Law and Tribunal rejected. Since you have not brought this fact before the Honorable High Court, the application for amendment was rejected.
No, at least you could have filed a separate GIA itself.
Because 2019 approval has been made. My GIA case, my lord, if I will file a separate, my GIA case was remanded for re-hearing. Where government has already filed counter, they have already soft copy in between after remand of the matter, my lord.
Correct. But that GIA, that the order which other person has sought, that is a different cause of action.
But
you file a separate GIA and these two GIA to be taken together.
I have not filed, my lord. I have not filed.
Permit you now to find that because of pendency of this this one.
GIA case. Again, subject to my again.
Yes, because that is how it's a separate cause of action, separate person.
If my lord will permit me, my application will be allowed, then I can take notice to the private party by adding him.
It cannot happen. It's a separate order. That order itself
but my lord, my prayer. So my kindly see my prayer before the Law and Tribunal.
Anyway, you have said it now. Your application could not have been allowed because you had focused a particular order which denied approval to your post in terms of GIA order 2008.
My lord.
Correct?
My lord.
But in respect of that post, some other person is appointed.
For GIA 2008.
Maybe.
My lord.
If that appointment is subsequent.
That appointment is approved subsequent, my lord.
That's what. Therefore, you should have filed GIA challenging that order. You should have moved an application for clubbing these two matters. Because post is same.
Post is same, my lord.
We will permit you to file it even now.
My lord,
within 4 weeks you file GIA.
My lord. My lord, in that even my lord, my first application which is pending.
That does not survive this order becomes.
My lord.
Perfect. Petitioner, appellant, please be seated.
My lord.
Has filed the GIA case number 592 of 2014, seeking a direction for approval of peon's post.
First.
CIA Order 2008. First term. The matter was dismissed by the tribunal, unilaterally acting upon the counter filed by the OPs on
11/11/19.
2019. First term. Petitioner filed FOA number
903 of 19.
9023 of 2019, which came to be allowed by a coordinate bench or region bench? By a coordinate bench of this court, while order dated
13/12/2024.
13/12/2024, and the matter was remanded to the tribunal for consideration afresh. First of all. Next paragraph. When the matter was pending, some other person came to be appointed to the said post of peon. The GIA was also accorded in his favor. Wide order dated
19/12/19.
19/12/2019. First term. This order the appellant wanted to challenge by amending his prayer in pending GIA case number 592/2014 by moving an application. First, the said application having been turned down by the tribunal, this appeal has been filed for laying a charge thereto. First term. Next paragraph. Learned counsel for the appellant vehemently argues that the application for amendment ought to have been favored by the tribunal in as much as the post in respect of which the litigation is going on is filled with another person by the order dated 19/12/2019, and therefore, without setting aside that order, arguably he would not succeed in the pending appeal. First, even otherwise, there is contiguity between the main prayer in the GIA and the prayer sought to be introduced by the application, which is now rejected by the impugned order dated 1/8/2025. First up. Next paragraph. Let the ASC appearing for the official OPs opposes the appeal, contending that the order dated 19/12/2019, whereby appointment to the post in question is made.
Approval
To the appointment to the post in question is made constitutes a different cause of action, and therefore the impugned order cannot be faltered. First up, I agree with this view. Next paragraph. In view of the above, the appeal being unworthy of merits is liable to be rejected, and accordingly it is. First up. However, liberty is reserved to the appellant to file a separate GIA case laying a challenge to the order dated 19/12/2019 within a period of 6 weeks.
3 weeks, my lord? 3 weeks?
4 weeks. 4 weeks. This appeal is of which year?
2014, my lord.
First. This liberty is granted in as much as the present appeal has been pending since last 11 years on the file of this court. First, in the appeal to be filed, all contentions are kept open.
For disposal, my lord, because GIA of 2014.
You can't seek disposal to file that one. Then you seek a clubbing of this along with that.
That GIA case, my lord, I will withdraw that GIA because that GIA, that 2014 GIA where I am claiming my approval and a subsequent GIA with liberty of this honorable court will file within 3 weeks. Here, in that case also, I can pray my approval along with quashing of that. In 2014 GIA, where my only prayer to approve my appointment. In subsequent GIA, which I will file within 3 weeks, in that case also I can pray my approval and quashing of the approval of opposite party by making a party.
First, it is for the appellant to file one consolidated GIA challenging the order
1912
dated. No, your order.
My approval was
rejection of your approval.
I seek approval.
It is open to the appellant to file one consolidated appeal, making the same prayer which he has made in the pending GIA 592 of 2014,
my lord,
along with a challenge
1912
to the order 2019 within a period of
3 weeks.
Week will give 4 weeks. 3 weeks. 3 weeks. First, if such an order, such an appeal, is it appeal?
GIA case.
So if such a GIA is filed, the issue of limitation shall not be raised. And the said GIA in contemplation shall be heard and disposed of within an outer limit of 9 months.
Both are same. Two matters are there. Only GIA and FAO number are to be corrected. Change.
See that there are two methods in that order is.
In that order, my lord, order dated same, but only GIA case number
712 it will be. This is
GIA 593.
GIA 593 is one.
And dated same.
Okay.
1912 date same.
Rest all things.
I beg.
Yes, come now. Yes, brother.
Yes. Beg apology for not.
All right. I also apologize for calling you before 2 p.m.
No, my lord.
I will say 2 p.m. Yes.
No, my lord.
I requested learned AG to call you here. Yes.
My lord, here, my lord, the petitioner is agreed by
louder.
Here, my lord, the petitioner is agreed by the action of the opposite parties in rejecting their application form, which has been issued pursuant to the notice under Annexure 1. The notice under Annexure 1 was issued by the OSEPA, inviting applications from the intent to provide vocational education training to the higher secondary schools and selected secondary schools, my lord. Pursuant to the notice.
First time it has come.
Yes, my lord.
You accept it. Learned AG is requested to accept notice for OP numbers.
What I humbly submit is that against initially they have issued a provisional rejection list. Pursuant to that, I have submitted my clarification. Basing on that clarification, they have partly corrected themselves. What they have done is that in the provisional rejection list, 2 objections that we have not submitted 2 set of documents. Upon our clarification, they have accepted that it's a mistake on our part. You have submitted, but we have not properly verified the application. Then after, they have issued the final rejection list, wherein they have admitted that out of the 2, the one is on our fault is on our part because we have not properly verified the application. The
other is yours.
The other they states that we have not submitted. But our stand is that along with the application form, we have submitted all the documents which has been required under Annexure 1, my lord. That Against that rejection order, we have submitted our clarifications and our communications under Annexure 8 to 10, my lord, which is pending, and they have not taken any decision on that, my lord. But
if that direction is given to take decision on these annexures,
they may reconsider, re-verify our application form, because final order has not been passed.
In a recruitment process, is it recruitment?
No, it's an
training process.
Empanelment.
Expression of interest.
Providing service.
In an empanelment providing service comes the issue as to whether the petitioner had submitted all the requisite documents along with his application was raised. First off, the petitioner contended that he had already submitted all the requisite documents and that the same were inadvertently not looked into by the OPs. Therefore, he made representations dated Annexure
1905 from 8 to 11. 1905 is the original representation. Thereafter, there were all reminders.
Representation dated 1905-2025.
Page 92, Annexure 8.
95. Followed by that Annexure 8. Annexure 8?
Annexure 9, 10 and 11.
Annexure, no. Original representation.
Annexure 8. Page 92.
8. Followed by reminders at Annexures 9, 10.
9, 10 and 11.
9, 10, 11. First term. Next paragraph. Learned AGA, having resisted the petition for some time, now agrees to instruct his official OPs to look into the grievance of the petitioner in the light of the representation and reminders at the earliest. If all contents are kept open. First term. Counsel for the petitioner is agreeable with this proposal. First term. In the above circumstances, petition is disposed of. First term. Time for consideration is 4 weeks. First term. It is open to the OPs to solicit any information or document from the side of petitioner if as are required for so and so. Web copy to be acted upon. One more matter?
Yes, item 36.
35.
34.
34. Who comes? Give that 34. Let us.
34 Planet friend was there.
34 to give it. Let us see.
Of course, it is a fresh matter.
It is in relation to release of salary.
Release of salary.
Any representation is made? Is it a representation? Just read last 2 paragraphs. No, you read and translate to me. You read it. I also need to understand.
এবং বিদ্যালয়ের বার্ষিক ও সহায়তাত্মক বিশৃঙ্খলা আচরণ যোগ্য বিদ্যালয়ের ମଧ୍যাহ্ন ভোজন কার্যক্রম আসন্তা 1/4/2025 ତାରିଖ ଠାରୁ କରିପାରିବି ନାହିଁ। ତେଣୁ ଆପଣଙ୍କୁ ହୃଦୟର ସହ ଅନୁରୋଧ କରୁଅଛି ଛାତ୍ରଛାତ୍ରୀମାନଙ୍କ ମଧ୍ୟାହ୍ନ ଭୋଜନ କାର୍ଯ୍ୟକ୍ରମ ସୁପରିଚାଳନା ପାଇଁ ଆବଶ୍ୟକ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରନ୍ତୁ।
What does he say?
That means she has given her unwillingness to work for the period as has been provided meal under the midday meal system. So approach to take necessary arrangements for the same because
Alternative.
she will not be there.
That representation is not considered.
That was not considered. So the follow-up some.
You accept notice and I'll call this matter next week. Short grievance is there, na?
This is a kind of show cause, my lord. Subsequently, page 20.
20.
Page 20. This is also in your letter.
This is issued by
This is in fact issued by the
BO.
petitioner concerned to the BU.
It's a Shuka notice. When any order is passed, you accept notice and come back. AG
Will intimate him.
Issue emergent notice. Learned AG is requested to accept notice for OPs. All OPs. Private. All OPs. Call this matter in the second option. Okay. You inform your friend.
Here, my lord, the prayer is limited also. Calling upon the opposite party so cause as to why appropriate deed shall not be issued to the opposite party, calling upon them to so cause for release of salary for the month of February within a time stipulated.
Yes.
That is the limited prayer of the and if at all fail to so cause insufficient cause. That means that all the way the sum and substance is to release the salary for the month of February 2025.
But just you answer, just go through anything is there, we can tell.
Then notice be issued.
That's what. In second week of September, I am calling this matter. Or you will consider the representation request for release of the salary in a time-bound way. Because it's not that simple. Shoka notice is issued, there is some reply.
Shoka notice
Therefore,
might have
that's
fixed
what. You come up with
the counter, it will suffice all this.
Correct. All right.
Will intimate.
Very good. On Monday, my sitting may be delayed. I do not know. I have to travel back sometimes because of rains and there will be delay. I may be delayed. Therefore, in the event there is delay, you have to condone it.
Your lordship's good guess, sir. It is all the way.